You said back then, when the Senate ceases to engage nominees in meaningful discussions of legal issues, the confirmation process takes on an air of vacuity and farce, and the Senate becomes incapable of either properly evaluating nominees or appropriately educating the public.
I do think that much of what I wrote in 1995 was right, but that I, in some measure, got a bit of the balance off. So what I wrote in 1995 was that the Senate had an important role to play, that the Senate should take that role very seriously, that the Senate should endeavor to think about what a nominee was, what kind of justice a nominee would make, and that was all appropriate. And I also said that I thought it was appropriate for nominees to be as forthcoming as they possibly could be. And I continue to believe that, and I am endeavoring and will endeavor to do so. I did think, as I suggested earlier, that I got the balance a little bit off. I said then, even then in that 1995 article, that it was inappropriate for a nominee to ever give any indication of how she would rule in a case that would come before the court. And I think, too, it would be inappropriate to do so in a somewhat veiled manner by essentially grading past cases. But I do think it's very appropriate for you to question me about my judicial philosophy on the kinds of sources I would look to at interpreting the Constitution or interpreting a statute, about my general approach to judicial decision-making, about the degree to which I would defer or not defer to acts of Congress and the states. I mean, all of those things, I think, ought to be a subject of debate.